Okay, so we are back before we pick up work with S23. We do have to take a position on a very minor change to the technical corrections bill, H463. Tucker is here to shed light on this very, very minor amendment for us.
Good morning, Tucker Anderson, Legislative Counsel. If you take a look at page 1695 of today's House calendar, you'll see towards the top in bolded H463. This is the Senate's proposal of amendment for the technical corrections bill. I am not the attorney who is working on this. I'm just sitting in the seat to tell you what's happening. It inserts the word to following the word pertaining in section 7, which amends 9 VSA section 206. So it is adding the word to.
Yes.
And that is the entirety of the amendment.
Okay, so we are adding the word to after the word pertaining to that rather lengthy technical corrections bill. So, yes, Representative Mango.
Is it possible to get the sentence that it's
being added to? Do we know that? I mean, I know I could look it
As a
up.
matter of fact, I can help with that.
Great.
So
That's the
this
technology.
technology, I have the bill in front of me. So in 3 VSA, this might not actually be the right section. Give me 1 second. VSA 2.
It's 9 VSA, right?
I think that might actually be,
Section 7, 9 VSA 206.
oddly enough, that is actually there are Scrivener's or printer's error because this is in 3 VSA section 206. So if you were to look at the bill as it passed the House, H463 as passed the House, page 5 in section 206, this relates to rules adopted by the commissioner. And do you want me to read the entire sentence?
Sure. Thank you.
The commissioner or board at the head of each department specified in this chapter is empowered to prescribe and to enforce rules subject to the approval of the governor for the government and administration of such department, the conduct of its employees, and the custody, use, and preservation of the records, books, documents, and property pertaining to the administration of the department.
Wow, somebody picked that up. That's pretty good.
So in as passed the House version in this section, there too was struck, but it was not replaced with anything. So it is now being replaced with two.
So now do we have to amend it? Now do we have to amend the section of?
What I would suggest is I will go to the House clerk in between leaving here and going to the Senate and just flag that this is something that should be corrected in the calendar and for purposes of.
Okay.
But we can still take a straw poll on the actual language amended. Yes. So, barring further discussion, straw poll to find the amendment favorable. Thumbs. All right, so that is at 1, 2, 3, 4, 5, 6, 7, 8, 0, 3 to accept. And we will let Representative Cooper of Burlington know. Thank you, Sarah. Now we're going to slide over to Mr. Sagal for S23.
Morning. Rick Sagal, Office of Legislative Counsel. So draft 1.2 is what you all should have. Is on the website, I hope, at this point. This is a proposed committee amendment to S23. S23, I believe you've taken some testimony over S23, the synthetic media and elections bill. And based on the testimony, we have a few proposals here that would amend the bill as it passed the Senate. Mr. Chair, should I just go through the amendments one by one?
That would be great.
Okay. So the first amendment, in the as passed by the Senate bill, we are looking at, if you have the underlying bill, you can follow along with me. It is on page 2, section 2032, subdivision A1. The line, it's the first sentence there. It's a long first sentence, but for deceptive and fraudulent synthetic media consisting of images and video recordings, the text of the disclosure shall appear in a size that is easily readable by the average viewer. So the amendment would put a period after viewer, and it would strike the following words, and not smaller than the largest font size of other text appearing in the visual media. The reason the proposal is to strike that second part of the sentence is because it could be too onerous on producers of media to have that text be as large as the largest text in the ad. Think about any commercial you've seen recently and how you have different sizes, right? Usually text in the ad. To require the ad have that disclosure, which if you don't remember, this is the disclosure. This media has been created or intentionally manipulated by digital technology or artificial intelligence. Depending on the font you use in an ad, that could be huge. So the preference here, and courts, I think, in my opinion, would be more kind to this law if we don't have it be as large as the biggest text on the ad. So the requirement here would just be easily readable by the average viewer. Any question about that?
Mhm.
Okay, the second amendment would be actually striking that next sentence because it's no longer necessary. It says if the image, on line 14 of the as passed by, if the image or video recording does not include any other text, the disclosure shall appear in a size that is easily readable by the average viewer. That was helpful before the amendment, but if we're going to amend it, the first instance, if we're going to accept that, then you don't need the second sentence because we're already requiring the text be in an average, in an easily readable by the average viewer. Okay, the third instance of amendment is on still same section 2032, subdivision B1A, which on the as passed by is on page 3, line 8. So this is the exceptions to the disclosure requirements. Subsection A of this section shall not apply to a radio or television broadcasting station, including a cable or satellite, et cetera. That A, broadcast deceptive and fraudulent synthetic media as part of a bona fide newscast, news interview, news documentary, and we are amending an insertion after documentary, which would say commentary of general interest. So the sentence would say, as part of a bona fide newscast, news interview, news documentary, commentary of general interest, or on the spot coverage of bona fide news events.
Is there a definition of that commentary of general interest? I mean, I get letters of it to the editor, but what about other like postings by people?
It's a good question. There's not. The reason I believe it was added is in the next subdivision 2, that same example was included on line 18. That it routinely carries news and commentary of general interest. And I believe you had some groups that wanted the language to match up as much as possible.
Representative White.
Yeah, this amendment comes directly from the Vermont Association of Broadcasters, and in their testimony, they refer to it as a legitimate analysis of news events that provides context to help the public understand complex issues. So I know it's not totally defined in statute, but she provided the example of like the round table that is frequently, I think in Vermont edition, the broadcast online where they are talking about what's going on. And if they were to talk about deceptive synthetic media, allow them to talk about it and do so.
Would a court agree, right? It's up to a court to, define that term. That's probably a pretty good definition that they provided. But if you don't define it in statute, then a court could maybe make that much more broad. And a commentary of general interest could be, I don't think I would call it sports, maybe, but some just kind of general news that is of common interest would be. But yeah, it could be considered more broad than maybe you might want it to be.
Mm-hmm.
The fourth instance of amendment is on the next page, page 4 of the as passed by. At the very top, these are the exceptions a person that produces or distributes deceptive and fraudulent synthetic media constituting satire or parody. So I think the issue was, what about a person that just shares a video that is parody, that uses synthetic media, satire? Would that person be protected? Maybe not. So if we add in or distributes, that would cover a person that just shares, retweets, whatever you call it, that sort of media. And the final instance is at the very end of the bill. It is changing just the section heading. You'll see on the as passed by 2041 injunctions. After talking with Tim Devlin, I think changing that to enforcement made more sense because this language provides more than just injunctions. It provides other AG enforcement or state's attorney enforcement that can be used to enforce the bill. And those are the 5 suggestions to amend the bill.
Any other questions from the table for Rick while we got him here? So oh, yeah, Representative Nugent.
For the 4th instance of amendment, would you mind just like reminding me and everyone here, that's me, where the liability is, like what is that about the person who distributes it or and produces it, or like just a little more context?
So the liability would be in a person that creates this ad that is a deep fake of a individual that is, you see the definitions, that appears to be a reasonable person, to be an authentic reporting of an individual saying or doing something that did not occur, right? So I think what this law does not want to lump into that definition are people making satire, parody, which I think I said before, this is a huge loophole, right? If you create something that is harmful and is using synthetic media, but you say, hey, I'm just being funny, it's just a parody, right? I don't take it seriously. That would not allow you to have the disclosure on there. So the language here is saying that not only if you produce this parody are you going to be subject to the law, but if you reshare it, if you tweet it, if you don't create it but share it, you would not be lumped in as being, targeted by this law. Does that help?
Do we distinguish between normally like a campaign that is producing material that's like against another candidate versus just a random person in law right now, as far as like assigning like who did it, like requiring disclosure?
As far as AI or just in general?
Just in general.
That's probably out of my element. I know there are federal laws relating what super PAC can do. If you are the campaign producing the commercial, you have certain guidelines you have to abide by. That's the same with mailers, same with commercials, billboards, not in Vermont, but billboards here. But if you are a super PAC or a nonprofit group that is supporting a candidate, then those rules are different. And you don't have to be quite as transparent about what you do. If you want more details, I might bring in Tim Devlin to go over that for you.
Yeah. So my goal today was to get this suggested language on the table for us, but also for interested parties who are tracking this. So of course, we'll have the weekend to sort of digest, marinate, and then we can revisit it next week. I didn't want to actually make a recommendation, insert any of this into the bill yet. I wanted to give her time to sit back and kind of comprehend what the impacts would be of these language changes on it. I mean, we're really trying to find a place to put guardrails on something that is so new that I want to be very attentive to what the ripple effects would be. So my ask is to just kind of marinate on this a little bit over the weekend, and then we can revisit it with the bill itself. We take it back up next week if that makes sense. Anything else for council before we call it for lunch? Nope. All right. Thank you very much.
Thank you.
Yes. Autumn,